All right. Are you ready for me?
Go
Okay.
for it.
Welcome to Guardians' Rights and Responsibilities in the Special Education Process. My name is Sarah. I'll do a little more introduction in a minute, but just a reminder that Pacer Center is not a legal services agency and does not provide legal advice or legal representation. The content of this presentation is for informational and educational purposes only. It's not legal advice and should not be used as a substitute for legal advice. And a little more about me. My name is Sarah McGinn, and I'm a Pacer trainer and or parent trainer and advocate here at Pacer. I worked in special education as a paraprofessional in both the elementary and preschool settings for almost 10 years. I really deeply loved working with students, and I had a passion for understanding behavior. I have 3 children of my own, and I found myself blindly advocating for one of them through their 12 or 13 years. And so it is through both my personal experience and my professional experience that I came to Pacer to help parents access the supports that are available to their children.
And I'm Robbie Weil. I came to Pacer after 35 years as an educator. 2 of my now grown children received special education services, and of course, I taught many children who received them as well. I never knew to contact Pacer Center, and as a teacher, I thought I fully understood the process, so I never did advocate for my children, or in some ways that I could have for my students. And I literally spent my first month at Pacer working as an advocate crying on the way home because I realized I had no clue, and I didn't have to second guess how my own children's trajectories could have been shaped differently. So I'm very passionate about getting this information out to parents early and often. So Pacer Center is Minnesota's Parent Training and Information Center, or PTI, and we have served in this role for over 40 years. After the passage of the Individuals with Disabilities Education Act, we refer to it as IDEA, in 1975, children with all levels of disability were given the right to learn alongside their peers, and guardians had both the right and responsibility to be equal decision-making members of their child's individualized education programming team, or IEP team. Pacer opened its doors in 1978 with a staff of 5 people and 1 project, Parents Helping Parents, with the goal of working in partnership to provide guardians the information, tools, and resources needed to build capacity as advocates for their children's educational needs. All 50 states are now required to provide free resources, training, and support to all guardians of children with disabilities through a state PTI. Again, everything is free to parents of children with disabilities. Over the years, Pacer has grown to a staff of about 75, and we now offer more than 30 programs. You can read more about all of these programs on our website, www.pacer.org. From birth through a child's 22nd birthday, transitioning into adulthood, Pacer works hard to partner with parents of children with disabilities and young adults. Our mission remains the same: to enhance the quality of life and expand opportunities for children, youth, and young adults with all disabilities and their families, so each person can reach their highest potential. While federal law sets the standard, state statute may give different specifics in terms of things like timelines or terminology, among other things. While we are happy to be sharing our information with anyone in attendance today, please understand that this webinar is based on the specifics of Minnesota statute. If you are in another state, please stay, but most of what we will share, because most of what we share will still be relevant. To be sure, you can use the Center for Parent Information and Resources website. It's called CIPR, CPIR, to look up your state-specific center. I also want to clarify a difference today if you have attended some of our other workshops. We have people attending today that are in very different roles. We have people here from varying states, and we are giving an overview of a lot of information. For that reason, we are suggesting not to use the Q&A at this time. We will probably end quite a bit early, before 1 o'clock, and we will open up to some questions at that time. However, Those questions could be across the board, and specifics are best answered by contacting PACER directly to speak one-on-one with an advocate about your situation. And we will be showing that information at the end. Oop, jumped a slide. Sorry, Sarah. There we go.
That's okay.
If you're interested on a personal level of learning more about how to share your personal story to impact change, be sure to check out our website again to learn more about our upcoming parent leadership training.
All right, I am going to go over the learning targets through this slide. IDEA, or the Individuals with Disabilities Education Act, is the federal special education law that ensures all children with disabilities have access to a free, appropriate public education, or FAPE. It is lengthy, written in legal terms, and is somewhat inaccessible if you can even find it. As parents, oops, of course I lost my spot here. As parents and guardians, we have developed a pattern of going to professionals to help us solve problems and then following through with what is prescribed. We could ask questions or look for a second opinion, but often we don't. Special education is different in that all decisions are team decisions, with the IEP team consisting of the professionals at the school and the parents or guardian. Every voice is equal, and decisions with very few exceptions are made by consensus. Parents and guardians are unintentionally at a disadvantage in the world of special education. They are asked to be an equal member and collaborative member of the IEP team without understanding the special education process, their rights or responsibilities in the process, and how that team works. Our goal today is to help you take your place at the table by coming away with a general understanding of the process. And therefore, the learning targets are a basic understanding of special education, a basic understanding of your rights and responsibilities, and an understanding of why PACER exists and how we can help.
The goal of general public school education is to provide students with what they need to know according to the standards as set by the state. When children are struggling, the school has a responsibility to address these concerns through small groups, interventions, Title I, and there are other ways as well, but sometimes it is clear that children need more. There are two laws that protect and serve those students. Section 504 of the Rehabilitation Act of 1973 protects the rights of people with disabilities participating in programs and activities receiving federal funds. When you think about sidewalks, the need to have a cutout for someone who is mobility impaired is also from that same law. In order to qualify for protection under this law, a person must have or be regarded to have a disability that results in an impairment of a major life function. Because learning is considered a major life function, a public school may not discriminate based on disability. All children are to be given access to the general education curriculum. Children with disabilities may need accommodations to ensure that access. That is done through a 504. There are no specific federal or state laws regarding how this happens, other than that you can't discriminate. Each district will have a 504 coordinator to contact to discuss the need for a 504. They will have their own policy and their own timelines. The other law is IDEA, or the Individuals with Disabilities Education Act. There are many laws that govern this process, including timelines, yearly reviews, due process, and participation, among others. Guardians are an important part of this process and participate best when they understand both their rights and their responsibilities.
Special education is a process with the goal of creating an individualized educational program, or IEP, for children who are eligible. The first step in the special education process is understanding and evaluating the educational needs of a child. And much like the foundation of a house, this is what everything else in special education rests on. So it is important that the evaluation be a complete and accurate picture of the child, or what we often refer to as comprehensive picture. This is done by looking at various data points that show the child's present levels of academic and functional performance in multiple developmental areas, which can include academic, cognitive, communication, sensory processing, and social emotional needs as examples. File review can include grades, state, and district assessments. And if the child is already on an IEP, then the current IEP, its goals, and progress reports can also be an important source of data. There is also a very specific process for evaluating the need for special education. Evaluation is considered when a parent or school staff member identifies a child with a suspected disability, and the team agrees that a comprehensive educational evaluation needs to be completed to assess how the disability impacts the child's ability to learn and make adequate progress in school. Typically, the evaluation process begins with a meeting to discuss all areas of concern by both parents and guardians, as well as school staff, to create a plan for assessment that addresses those concerns. If the child is undergoing a reevaluation, then the current IEP and progress reports can also be an important source of data for the team to consider. When a parent has a medical evaluation, such as a neuropsychological evaluation, the team must consider the information, but it is not required to use to determine eligibility. A medical evaluation gives parents detailed information about a child and sometimes a medical diagnosis, whereas an educational evaluation looks at how that suspected disability impacts their ability to learn in the school setting. Special education is provided for those who qualify and uses services and supports that provide FAPE, or a free appropriate public education under IDEA, to that child. Once the team has agreed to an evaluation, the district has 30 school days to complete the assessments, write the report, and present it to the guardians. A meeting is then held to go through the evaluation, and there are two important questions that should be addressed at that time. The first is this evaluation a complete and accurate picture of my child's needs? And is the child eligible for special education services in one of 13 categories with criteria set by the state of Minnesota?
We know that we are sharing a lot of information. As Jamie mentioned, registration for this workshop includes a resource page, which has links to some of our YouTube videos from a series that gives more extensive learning about the general process, as well as one geared specifically to the evaluation process. And again, questions about where you are in that process can be directed to a special education advocate. After the evaluation is completed and that meeting is held to go over it, the needs are looked at to see if they meet criteria for eligibility for special education services in one of these categories. These are the categories that are laid out in federal law and then refined by the state, who creates the criteria for qualification. It is important to understand the difference between a medical diagnosis and an educational category. And having an outside diagnosis does not automatically mean that a child will qualify for special education. And I'll talk about some examples in a minute. Some schools will refer to it as a school diagnosis. It's not a diagnosis. It's just looking at those needs and which criteria checklist, if any, they fit under. Sometimes children will not qualify under the initial category suspected, but an evaluation might identify additional needs that would then fit into a different category. Some of these categories are, of course, self-explanatory, but I do want to point out a couple of things. The autism spectrum disorder category. There are many children who never even have a diagnosis or a suspicion of actually being a diagnosed child with autism, but they do qualify under that category. It's not a school diagnosis. Conversely, there are many children who have that actual diagnosis, but don't meet the criteria to qualify in that category. Another one to point out is developmental delay on the left side as well. This is a kind of catch-all category that can only be used until a child's 7th birthday. It kind of says we see delays in some areas. We're not sure what category might make sense, so we're going to give services through developmental delay. Again, a new evaluation has to be done by their 7th birthday, and that is when they look to see, do they qualify under one of the other categories. As I mentioned, most of these categories do not need a diagnosis. A medical diagnosis is very different than educational need and meeting a category. However, other health disabilities is one category where you do need to have verification of a child's diagnosed disability. For example, if you have a diagnosis of ADHD, this is the category that would potentially be looked at. It's where many of those children fall. And that diagnosis has to be confirmed every 12 months. There are many children with other medical diagnoses who also qualify under this category.
If a child is eligible for special education services through one of the 13 categories that Robbie just described, the next step in the process for the IEP team is to create an individualized educational program, or IEP. The IEP team must come to an agreement in a few areas: prioritizing needs, creating appropriate goals, and deciding services and supports to address those identified needs and meet those goals. When in agreement, the team can then create a plan that is designed to address those students' identified needs through supports and services in the IEP. The needs are like the first floor of a house, and then those supports and services are the second floor, built to address those needs. IDEA states that a child with a disability may not be removed from the regular education environment if the child's education can be satisfactorily achieved in regular classes with the use of supplementary aids and supports and services. This is called the least restrictive environment, and it is an important part of IDEA. This is the last step in the process, or what we refer to as the roof in our House of Special Education, as you can see on the slide. Special education is not a place. Rather, it is a percentage of time away from typically developing peers to receive those agreed upon services in their IEP. That percentage is what determines the placement, with the goal being the least restrictive environment, balancing the individual services and needs that a child needs away from their typically developing peers, along with their right to learn alongside those peers.
So we're going to dig a little deeper into the rights and responsibilities that come with those rights. IDEA gives parents and guardians many rights and responsibilities. They are presented to a parent yearly in the form of a packet titled Procedural Rights and Safeguards. There's a lot of paperwork in the special education process, and reading through IEPs, progress reports, evaluations can be very overwhelming. Many parents, myself included, never read through that packet, wrapping my brain around everything else. So let's go through some of those specific rights. You have the right to request an evaluation. While the school staff may refer a student for an evaluation, you also have the right to ask the district to evaluate the child. Under the part of IDEA called Child Find, schools are required to locate, identify, and evaluate all children with disabilities from birth through their 22nd birthday. When you've requested an evaluation, if you are denied, there are ways to push back on that. Again, I refer you to our video that you have received a link to about evaluation, and this is a question we walk many parents through. You have the right to review and make copies of your child's records, including report cards, transcripts, disciplinary records, contact and family information, cumulative files, and all their special education records. You can ask for those records to be explained to you by a qualified staff person, and you can also ask for misleading or inaccurate information to be removed or changed. You have the right for your opinions and concerns to be considered. You are the expert on your child. The school members of the team hold the expertise in terms of pedagogy, curriculum, and how your child is impacted during school. Sometimes there is a discrepancy between home and school. That doesn't mean that people are seeing something or saying something wrong. When there's a difference between how a child performs at home and at school, that could be a difference that exploring could help identify additional needs. You have the right to bring anyone with you to the meeting that you believe is relevant. You never have to go it alone. You might want to have someone there to take notes, to bring relevant information, or simply for moral support. The last right, I think, is one of the most important rights because, again, the process doesn't go forward unless there's consensus. You always have the right to consent or object to any proposal, and a proposal should come from almost any IEP meeting. So let's look a little bit deeper at how that happens.
Next, we're going to talk about the right for a parent to agree or disagree. There's a document that's important to keep in mind called the prior written notice, which is an important document in the special education process. It is shared with guardians and parents when the school proposes or refuses to do something related to the identification, evaluation, placement, or provision of services for students in special education. It is accompanied by the parental consent and objection form, which parents can use to exercise their right to agree or disagree with that decision. If the parents are in disagreement, this form also unlocks their dispute resolution option. It is important that guardians and parents understand that they do not need to sign anything at an IEP team meeting except for the attendance sheet. An IEP meeting is a time to get your questions answered and for your concerns to be addressed using that process. PACER always says, if it is not in writing, it does not exist. It is important for parents to put into writing at the end, any end of school day chats, discussions at drop off, those conversations you have during conferences, and include in those in that documentation any action steps that were discussed. Parents can also use the special education process by always asking for a prior written notice if something is being denied or proposed. Parents always have 14 calendar days to respond to the proposal or refusal in a prior written notice with their agreement or disagreement. If you do not return the parental consent and objection form by that date, which is the date sent to you written on the prior written notice, by default, you will have given implied consent and the school can move forward with a proposal or refusal, except in the case of initial evaluation or IEP, which will require parental consent to move forward in the process.
So the rights that are part of IDEA give you the power of being an equal member of the term, but much as Spider-Man would say, with great power comes great responsibility, and parents also have responsibilities within the system. The first is to know your rights. You can't exercise your rights if you don't understand them. Many parents call us when there is a problem that could have been avoided had they known how to express their concerns, how to object to a proposal, or what their options were. You also have the responsibility to learn as much as you can about your child's disability and its impact on their education. Your child may not be the first child in the school with an ASD diagnosis, but your child is an individual and may be impacted very differently than other children. And again, you're the expert on your child. Your child may have a genetic syndrome or diagnosis that the school has not dealt with before. And so the information you bring can be vital in the decision-making process. You have the right to make informed decisions about your child's education. And again, that's where becoming informed about the process and your rights is crucial. I tell parents when they sign the consent form, if they're giving consent, you want to be doing that with confidence. And the more you know and the more behind the scenes work you do, the more likely you are to feel that confidence. Also, learning to communicate in an effective manner allows teams to work collaboratively. In essence, you are in a business partnership with the school, and the product is the plan to educate your child. This is where we talk about with parents that, assuming best intent, going in meetings with an understanding of here's the problem and coming up with the solution together. It is not you against them, and it's not a democracy. There might be 7 people from the school part of the team and one of you. You can't be outvoted. Again, it's about consensus. How you do that is what can make or break the team and the collaborative nature of it. Disagreeing is not being disagreeable, but again, there are ways to do that preserve those relationships with the rest of the team. And again, there is a link in the resources to our workshop about effective communication with the team.
And this is why PACER Center exists. So I, like Robbie was sharing before, I did not know the special education process. I didn't know my rights, my responsibilities, or things I could ask for my own child. And so PACER advocates are that connection between parents and the special education process. Like we said before, Pacer Center is Minnesota's Parent Training and Information Center, or PTI. We offer parents one-on-one support, as well as resources for parents and guardians, including educational materials and workshops like this one, as well as the others that are linked in the resource page. Some people think of Pacer as a place to call when there is a problem, a hammer to pound the team into doing what they want or should do. But in fact, we like to think of ourselves as the grease, helping all those gears work together smoothly through the process. We help parents become active, collaborative, and equal members of those IEP teams by helping you to understand the special education process, your parental rights and responsibilities in the process, and ways to solve disagreements when they arise. Also, it is helpful to call Pacer earlier than later when your problems are small, or maybe when you're needing to learn a little more about the process. That helps us help you a little bit more, and it is never too early to call for support. We talk to parents through every step of the way, from thinking about requesting that evaluation to feeling really confident about the IEP plan. In fact, contacting us early in the process is actually part of the responsibility under IDEA. By helping you understand the process, we help parents keep those problems small and manageable.
Whether you call or email, please be sure to share the following information: the age and disability of your child or suspected disability, excuse me, and 2 or 3 sentences summarizing what your specific concern is at the moment. That can help us make sure that your questions get to the right advocate. While we are all generalists, some of us work more with certain kinds of families or have more expertise because of our personal experiences. We do try to respond in a timely fashion to all people who contact us, and we know that every parent, their concerns about their child seem urgent. We do try to reply within a 48-hour time period of receiving your email. However, if you have an important deadline, for example, a prior written notice that is due in 2 days, or an already scheduled meeting that you want help preparing for, that information in your initial message can be very important in making sure we get back to you in a timely fashion.
Pacer Center advocates are always just a phone call or email away. In the screen, you'll see our main phone number. You can leave a message there for an advocate to reach out to you. You can reach us via email, or you can provide your intake through our contact form on www.pacer.org. This is also the website link where you can find all of our resources, and there's a search bar to help you to help guide you in that search. Please understand that today's workshop is intended as a basic overview, and since we covered so much ground, we will just be taking a few questions depending upon the time we have today. Feel free to contact Pacer directly to connect with an advocate. Remember, the earlier the better, and we can also talk about the specifics of your situation. We are always tweaking, updating, and adding new workshops, so please take the time to fill out the evaluation that will pop up as you log off today. It only takes a minute or two and is very helpful to us. Here are some upcoming workshops that I want to mention for you that are coming up on our website. Planning an IEP team meeting for your child with mental health challenges. Creating the Vision, Housing for Young Adults with Disabilities. Assistive Technology for Dyslexia. And Special Education for your child in the summer. We also want to share a couple Pacer events that are coming up, and Robbie will share those slides with you.
So we have our day at the Capitol. I'll be very honest, and just so you know, we will have some time for a few questions. We have a couple in the chat, and they are general enough that we should be able to answer them. We are getting a lot of questions right now about concerns as to what is happening in the world of education on a greater scale. Our day at the Capitol is your chance to have your voice be heard in terms of how you have experienced the special education system, what has gone well, what hasn't, and what might be helpful in helping your child succeed. Again, the leadership training that we talked about early on culminates in attending this together. So again, Day at the Capitol is open to anybody, but if you do think about doing the leadership training, that is in part preparation to then go to the Capitol and share your concerns. And then last of all, of course, we work a lot on funding through grants, but we also are always looking at ways to make sure that we can continue to offer for free what we have. And one of the big ways we do that is from our gala. This year it is on Saturday, May 10th at the JW Marriott, and that QR code will bring you to information. Again, when you log off, you will see that evaluation. Please take the time to do it. It really does help us. Not only do we use it in our inner way to tweak and add, but it is also how we're held accountable for doing what we are tasked with doing through our grants. And at that point, any of you who need to leave, please go ahead. Sarah, you want to go ahead and answer that first one, and then we'll just kind of move through these questions.
Yeah, so the first question is, so we should not hear so we should not hear that the team voted and you were outvoted. This person is stating this was a real statement from a team. Anytime there's a disagreement during an IEP team meeting, you can ask that that be put into writing in a prior written notice. And that's where you would have that ability to exercise your right to agree or disagree. And then that would unlock some of those dispute resolution options to kind of have that discussion further. And that would be a good time to reach out to a PACER advocate if you have any further questions about what that might look like after you send that form in.
So the next one has to do with the rights for a homeschool child, with the question being, you know, a school did not differentiate for a child who was 2E or considered twice exceptional in terms of giving accelerated differentiated curriculum. The truth is, and as someone, again, who taught for 35 years, it's hard for me to admit that there is no obligation of the schools, we're talking in general, to help child meet their full potential. So whether districts have gifted talented programs or not, whether they're willing to differentiate curriculum, from my perspective, that's best practice, but there's no way to make them do that. The question also referred to, can you make them then pay for a private program that would best fit them? Again, they have no obligation to do so. They do have an obligation to meet their special education needs. And there are very rare situations where parents have gone through due process hearings to have a school pay for placement in a program when the district cannot meet their needs. But honestly, in my 6+ years at PACER, I've never experienced that. And again, when a child is on an IEP and has that high potential, you know, you might want to call and speak specifically to an advocate. There are ways to push for additional services. When you are a homeschooled parent, you are responsible for their education. You can still receive special education services. The district has to stand ready to serve all children, and you in effect have become your own private school.
Okay, the next question, I can't tell if it's from a parent or a professional, but the answer is the same regardless. But I have often wondered when to recommend a neuropsych or an IEP evaluation. So as we kind of discussed in a slide earlier in the presentation and webinar, that neuropsych evaluation is a medical evaluation that is completed by a medical professional. And it does give a lot of similar information that a school evaluation would give. However, it is diagnostic. And so that means that a parent can get medical diagnosis from that neuropsych evaluation. And there might be some recommendations. It's a very long, anyone that's had a neuropsych evaluation, it's a very long report with a lot of detailed information, including a lot of recommendations at the end. So an IEP evaluation has some of the same testing that is, and assessments that are performed, but they're looking at how those identified needs impact that child's ability to make progress and learn in the school setting. And so when a parent comes to the table or calls us and says, hey, we have this neuropsych evaluation that says this child would benefit from IEP services, or you know, that they need these accommodations. The school only needs to consider that information. When a parent shares that with the school team, they don't have to use that to make a determination for eligibility. And so I hope that makes sense. So sometimes it can give beneficial additional information, but that IEP evaluation specifically looks at eligibility and how those needs that are identified impact that student in the school setting.
Thanks, Sarah. Just up. Do you have to use IEP services when qualified, or can you sleep an IEP service until necessary? I guess my easy answer to that is the evaluation has suggested that they are necessary at this time for the child to make progress. Parents and guardians do have the right to revoke services. At this time, there is kind of an all or nothing approach. You can't say, well, we want this, but we don't want this. You know, the purpose of a good evaluation is to identify needs. And at that point, the school is obligated to meet those needs. So they're obligated to propose an IEP that addresses all the things that have become clear through evaluation. You have the right to think on it. You have the right to say, we're not going to take these services right now and revoke them. You know, it depends on how long down the line you change your mind as to whether there may be a need for a new evaluation or where they would go back in the process. But again, you know, if the service isn't necessary, it probably wouldn't be in the IEP, I guess, is the simple answer to that.
Okay, so the next question here has to do with who are the other important people to invite to the IEP team meetings besides the team itself and parents. So a parent has the right to bring along anyone to that meeting as a role as simple as the person that's taking notes, or the person that kind of keeps you in check if you're coming to that meeting with intense feelings or a history with the school that maybe there's a lack of trust. Or you could even invite professionals, like outside professionals that work with your family, that may have important information about how that student might benefit from different supports or input as far as what those services and supports can look like, such as a therapist, an outside therapist. Sometimes parents ask for written responses from paraprofessionals that work with the student. If they have an outside OT or speech therapist, sometimes they can give written input if they can't be there physically. And then another question in the same response here is that we ask the team to answer questions, and sometimes they say, just wait till conferences. Other times the case manager will just answer questions. So if parents have concerns about their child's IEP or the progress or goals or anything kind of contained in that, you can ask for an IEP team meeting at any time. That if you're not getting the response from the case manager and it's not addressing your concerns, we would just recommend that you share that in writing in asking for that IEP team meeting. If you're not getting that response that or getting those concerns addressed, with that case manager, you also have the option to ask that the special education director be involved. And I like to recommend that parents kind of keep that transparent with the case manager. Just because you are in that working relationship with that team and that case manager is a part of that team. But if you're looking to have your questions and your concerns addressed and you're not making progress with that team or case manager, then that special education director can sometimes be helpful to bring into that conversation.
Okay, so the next one, when do you know it's time to do an IEP evaluation? Again, this is a question that we will often talk with parents about. We get those calls like, my child is struggling, and we'll talk through, do you think you would like a 504 evaluation? Is this a reasonable time to request an IEP evaluation? There's no easy answer here. It depends on how your child is being negatively impacted. And that's the key here. Now, that doesn't necessarily mean academics. They may have good grades. That doesn't mean that they don't have needs that are impacting their education negatively. It is a fact, however, that this is a system of failure. So your child has to be struggling to a point where they are not going to access their free and appropriate public education without some kind of support. Again, I get calls from parents and we'll talk about what kind of evaluation they might want, what makes sense, and whether the request is reasonable. I have had to have that difficult, and I'm sure Sarah has too, conversation that the fact that your child is getting an A-, and they have ADHD, but everything else is going well. There's no behavior issues. They're staying on top of their work. That's not a reason to request an evaluation. You still have the right to do it, but it doesn't, you still have the right to do it and you have the right to push for it. But again, I often will share the criteria checklists with parents and talk through, do you think your child, based on what you're seeing in any of those areas, behavioral, social, emotional, academic, do you think they would meet these criteria? One of my pet peeves is when a district says, well, they won't meet criteria. And I use I think in analogies, I use the analogy of testing a cake. That's like, well, we've watched them. That's like sticking a toothpick in a cake and saying, yep, it's going as it should. That doesn't really tell you if it's not going as it should, where the problem is. So you can't tell if a child will qualify unless you do the assessments, if there's enough concern there. The other times that you do an evaluation, every 3 years, the evaluation needs to be updated. The IEP annual meetings kind of serve as a check-in towards the goal for the year, for that 12-month period. It's not from September to April, it's from whatever date your IEP renews. And then every 3 years, they have to do a new evaluation again to dig a lot deeper and see, are there still needs? Are there new needs? What does that look like? When a child has a new diagnosis or a child is continuing to struggle, you've tried to make changes to the IEP, that might be a time to also discuss moving up an evaluation.
Okay. So I'm going to answer the question here. Is a report from a dyslexia center considered a diagnosis? So I get a lot of this question in the daily intake of calls that I take here at Pacer about dyslexia. So there are certain tutors or centers that give parents reports with diagnoses of dyslexia. So if it's not coming from a medical professional, it is not considered a medical diagnosis. And something to keep in mind when you have this information is that usually it's identifying certain needs within kind of those reading skills or writing skills or math skills. And what those needs, what we want to look at is how those needs might impact them in a school setting, because having a medical diagnosis of dyslexia or a reading center, evaluation that says that there's dyslexia, that doesn't mean that the student is going to qualify for special education services. They would still have to go through that evaluation, that educational evaluation for special education. To assess those needs in those areas. And that would be when the parent, may present that information to the school, but say, here's what I see is impacting my student in the classroom. Here's how I think that's occurring. I see this, I noticed that. And then that educational evaluation is the only way to know whether that student would qualify for services under that category of specific learning disability. So that just like Robbie was saying in an earlier slide, having a diagnosis doesn't automatically qualify a student. It's more, what is that educational impact? And if you have any further questions about that, you can reach out to a PACER advocate.
I'm just going to clarify, Sarah, we still have 75 people here. So I think that these are all, I've got time if you've got time.
I do, yeah.
We will have a hard stop at 1 o'clock though. So there's a couple of questions here from somebody, and I noticed that you said you have worked with a PACER advocate. I would suggest calling your advocate back, but I did want to address one thing. So this parent says that they did craft an email requesting a formal evaluation and waiving the interventions, the process doesn't stop there. You should be asking for a prior written notice. You know, here's my request. I often suggest that parents actually ask in that request, I would like to either A, receive a meeting to start to plan the evaluation, or B, receive a prior written notice denying the evaluation. I intend to object and ask for another meeting. And that's something that we can then walk parents through. But again, this person is also stating that their child's day has been amended. From our perspective, that is potentially, not always, sometimes that's a really viable option, but it's based on the needs of a child. So when they say, well, your child's struggling, we're just going to amend their day because we think they'll do better 6 hours instead of 8 hours. That's not based on the needs of the child, and potentially they're not receiving FAPE. So sometimes, again, that is a viable option, but there is a process to go through that, and you don't ever have to agree to that. Again, you have the right to consent or object. But again, for that particular one, I would suggest that you call and talk to your advocate, since you've already been in touch with somebody, to talk about those next steps if they didn't respond to your request.
Okay, I have a question about being able to record meetings to have access to a reliable record of what happened. So whenever I hear this question or see this question, it always kind of feels, like maybe there's a history or a past between the team where there's some distrust. And so I can understand this question. However, a meeting cannot be, and Robbie, correct me if I'm wrong, cannot be recorded unless you have permission of everyone at the meeting. But also we kind of look more towards what is the purpose of that recording. So if a parent requires that accommodation because they themselves have a disability, that is a discussion that can be made beforehand to see how the meeting can be captured for that parent to be able to have better access to what is discussed. Another option is bringing someone with you to the meeting that can keep notes and be a second ear and listening, so that you have another person that has taken in that same information. And I don't know, Robbie, if you have any other suggestions.
So, I mean, what I often talk to parents about is exactly what you said. This implies to me that maybe there's a level of distrust. Let's talk about that. Depending on the seriousness of the distrust, there are options like mediation to work through that. And again, I have had parents who have their own disability and will record a meeting so that they can listen to it again at home or take notes. But it is best practice. I think that the law, I don't know the specifics, and we're not attorneys about recording people, but I would say it's always best practice to just ask permission. I did work with a parent recently where they asked permission and the school said, great, but we will be recording it as well. And again, that speaks to me that there's a level of distrust there that could be addressed. There's a question here about, when is a title intervention enough? When do you need to request an IEP? And don't apologize for your questions. I'm glad that we had time to answer some. Again, it depends, and that this might be a time to call and speak to a PACER advocate. What we know is that some kids with a little bit of intervention start to make progress. It's when over time they're continuing to either decrease in their ability to make progress, the gap is widening, that you might want to consider an IEP. But again, the specifics in this case might be really important, so feel free to call us.
Okay. I have a question that says, what are the basics of special education again? And also, what is the process? And so I thought this was a good opportunity to plug all of our PACER resources. So when you are attending a webinar, it's important to know that they're always recorded and posted pretty quickly to YouTube. And the YouTube channel for PACER Center has a wealth of information on different topics that a parent can access. So sometimes those printed resources don't provide access to all parents in a way that makes sense. And so those webinars can be in addition to that, or can be as a good supplement, or a better way for you to access them if you're more of an auditory learner. But also kind of keeping in mind that health. So we talked about special education as a health. And so when you are a parent who is approaching that house for the first time, and there's a process to enter that house, and that is that requesting that evaluation. And then there's that foundation of the house, which is that real comprehensive evaluation that identifies those needs for that particular child, which is that first floor. And then that second floor is those services and supports that are created to address those needs. And then the placement, or that least restrictive environment, is that percentage of time that they receive those services in school. So I encourage everyone here to reach out to those resources. And if you have more specific questions, reach out to a PACER advocate to talk through that. And then Robbie just shared in here a link to our YouTube channel for all of those workshops.
So there are a couple questions here about expulsion and suspension. Children with special needs can be suspended. They can be disciplined. Sometimes there can be differences written into the IEP as to how that is handled. There is something called and I think the question relates to, what if the behaviors they're being suspended for or potentially being expelled for are a manifestation of their disability? So when I get these calls, the first thing we talk about is, why is your child continuing to struggle when they're on an IEP? And that then suggests that we do a review. And this is something that we do with parents all the time. We review with them the evaluation. Actually, you review it and then we answer your questions and discuss it. We compare it to the IEP. If they're being suspended for things, is it because are there additional supports? Are there different goals that could be put in place? What is happening? Sometimes that can be addressed simply through the IEP. Sometimes it's because, and there was another question in this regard, maybe these are new and that might suggest additional evaluation, or reopening the evaluation, or adding some new assessments. But there is something called a manifestation determination. Parents have the right to ask for this at any time, but the school is required to do it upon the 11th suspension, or after the suspension after the 10th. I'll explain manifestation in a second, but I also want to mention that a suspension is anytime a child is being sent home. And if they call you at 10:30 in the morning and saying your child has to come home and we're suspending them tomorrow, you have the right to say, no, you're also suspending their education today. So today is day 1, tomorrow is day 2, if you're saying it includes tomorrow. Schools don't always follow that, but anytime, again, you are called and told your child is going to be suspended and is being sent home at this time, clarify that you want a notice of suspension both for the day that they're being sent home and the day that they are technically being suspended for. The manifestation determination is a meeting that talks, number one, about, are these behaviors impulsive things like behaviors or language? Is that a manifestation of the child's disability? Very often the school easily answers that question, that yes, this is a manifestation of their disability. The second question that then needs to be addressed is it because the school is not following the IEP? Is the IEP services and accommodations and other supports being implemented? If there is anything on that IEP that is not being followed, then there's no way to know if the child would not have been suspended if it had been. What that does is says this suspension is due in part to the grown-ups not doing what they're supposed to. If in fact the finding is that, yep, we are following this IEP, then it is not, then the answer to that second question is like, yes, we are following the IEP, but that still indicates that the IEP isn't sufficient. And then that review process and changing things can become really, really, really important.
And Robbie, just a note, I did share the discipline
great.
guide, the interactive discipline guide. So PACER has a really great interactive discipline guide that kind of walks you through when suspension, is becoming a concern with your student, but it's very easy to use. Okay, so I have another question about 504 evaluations. Does the school do a 504 evaluation? And if so, what does it look like? Or do they bring in a diagnosis and the 504 is written based on this medical diagnosis? So much like IDEA and special education law, the medical diagnosis doesn't automatically qualify a student. They have to show a need through their 504 evaluation, and that is determined through your home district's or your school district's 504 process and procedure. So those are different, a little bit different per district, those procedures that they follow, and that includes those evaluation procedures. So if a parent has a concern that their student needs accommodations in order to access their education, they can make a request for a 504 evaluation through the 504 coordinator for your school district. So it's as simple as opening up a Google search and stating, district, whatever, and then 504 coordinator. The school is required to have a 504 coordinator. And sometimes it's really hard to find in certain cases. And if that's the case, just reach out to Pacer Center and we can help you move forward. But that 504 eligibility is based on need, and to do so, you have to just show that there is an impairment in a major life function. And that can be through a diagnosis, but also if there's impact on them in the classroom, that is shown through that evaluation, where that student then can get 504 accommodations and supports.
And I think we're gonna have to wrap up. So if it's okay, I'm gonna take these last two just kind of quickly. As we said, when there is a decline in any area, if your child had been assessed and did not qualify, you can always ask for a new assessment if there's a change in any way. So that evaluation is always available to you. Many times the children just don't qualify at a certain point, and down the road, issues start to become bigger, and then bringing what they tend to do in those situations, depending on when that first evaluation was done, they may do a review of record of some of the assessments that you all agreed do not need to be repeated and add some additional assessments. And again, that question about, and it kind of relates, when a child is assessed and the school doesn't see the impact because the child is masking and they go home and they fall apart. Sometimes that has to do with the assessments that were used. That's a conversation that I have with a lot of parents. So what's going on here? It's important to understand that masking is a coping skill. And when it reaches a tipping point that they can no longer access their education, then that can be addressed. But there, again, are ways to use evaluation and specific assessments to include that outside information. Again, that's another one where I think it might be best for you to call and talk to a PACER advocate. And I know Sarah's typing an answer to somebody else. Somebody here spoke to Judy yesterday. Lucky you, she's amazing. There's a bigger question. How do we trust strangers in times we live in today? Wish we could answer that. You want to have good communication with the team. That's what we are exactly here to help you do. So again, feel free to call us at any time, questions or concerns. We really appreciate you being here today. Anything you want to add, Sarah?
No, I just can't type fast enough, but nope. Thank you for being here today. You guys asked really great questions.
And again, check our website for upcoming workshops as well.
Yep. Have a great day, everyone.
All right. With that, I will end today's webinar. Thanks for everybody for attending.
Bye.